Hello everyone, my name is Brooke Griffiths, and today we will be discussing employer social media policies and some common employee protections under the National Labor Relations Act. To begin, let's start by defining what social media is. Social media are forms of communication that allow people to create, share, and/or exchange ideas and information through the internet. The image on this slide provides us with a global digital snapshot. In January of 2017, there were 2.789 billion active social media users and 2.549 billion active mobile social media users. This slide shows us the digital growth. In January of 2017, compared to January of 2016, there was a 21% increase, or 482 million more active social media users, and a 30% increase, or 581 million more active mobile social media users. As the previous two slides have just demonstrated, social media use is widespread. As a result, businesses face new legal and ethical issues. Social media posts have been used in litigation discovery to establish someone's intent. Intellectual property may be compromised and infringed upon. Posts can be used to reduce damage awards, as well as in criminal and illegal activity investigations by both law enforcement and administrative agencies. Given the widespread social media use today, it should come as no surprise that many employers now have social media policies in place to establish specific guidelines outlining appropriate social media use for their employees. Some people argue that social media policies may violate the protections under the National Labor Relations Act. The National Labor Relations Act outlines provisions for protected concerted activity, which provides protection when two or more employees act together to protest and/or complain about their work conditions, their wages, their benefits, or any other terms of their employment. If the content of an employee's social media posting contains complaints about their working conditions, wages, benefits, or other terms of their employment, and involves at least one other employee, one could argue this activity falls under the protection of the National Labor Relations Act. Despite the National Labor Relations Act protections, employees who use social media in ways that violate their employer's stated social media policies may be disciplined and even terminated. Up until this point, courts typically uphold the right of employers to terminate a person based on their violation of policies, even those policies related to social media use. Employers continue to live with some degree of uncertainty while they wait to see if the National Labor Relations Board will declare their social media policies to be in violation of the National Labor Relations Act. While most employers tend to draft their social media policies using what most would consider to be in keeping with common sense and business interests, their policies could still violate the National Labor Relations Act. So how can employers avoid violating this act, but still have a social media policy? Christopher Casson, Crowell and Morning, LLP, offer some do's and don'ts for employer social media policies. The do's. Number 1. Narrowly define any prohibitions on employee social media behavior. Be specific in your definitions and examples of the types and categories of information that is prohibited to disclose. Number 2. Require employees who are posting about work-related issues or company products and/or services to include a disclaimer that identifies them as a company employee and specifies that their views are their personal opinion and do not reflect the opinion of the company. Number 3. Require employees using social media on behalf of the company to sign a separate written agreement outlining that the account itself, the content of the account, and any lists of friends, followers, or contacts that are developed using the account are the property of the company. Also spell out procedures for the employee to turn over control of the account to the employer upon the employer's request and/or upon the employee's termination, and make clear that the employee is not to use that account for any personal use. Number 4, consult legal counsel to review any proposed disciplinary actions related to an employee's social media use to ensure that it does not violate the National Labor Relations Act provisions, as well as review the proposed implementation or revisions of said policies to ensure that the latest trends in the National Labor Relations Act treatment of social media policies and issues. The don'ts. Number 1, do not include savings clauses or an exception in a law, as these clauses currently are not recognized by the head of the National Labor Relations Board with regards to social media policies. Number 2, do not include blanket provisions related to defaming or otherwise damaging the reputation of workers, clients, or the company, as these are considered violations of the National Labor Relations Act. Number 3, do not prohibit employees from using the company's logo or branding in their social media posts, as these are considered violations of the National Labor Relations Act. Number 4, do not prohibit employees from posting information about their wages, hours, or other working conditions, as the National Labor Relations Board maintains that these are terms and conditions of employment that employees are free to discuss under the provisions and protections of the National Labor Relations Act. Number 5, do not forbid employees from using social media to contact traditional media outlets, as this also violates the National Labor Relations Act. Employers can, however, require that employees clarify in social media posts that they are not speaking on behalf of the company. These guidelines will provide businesses with a solid foundation when creating, revising, and/or implementing social media policies. However, it is important to recognize that this area of the law is still in flux. The National Labor Relations Board decisions involving social media policies have not reached the United States Courts of Appeal. It is possible that they may be overturned or amended significantly, and therefore employers must stay informed on any developments in this area in the coming months and years. The final slide for this presentation contains the sources used to inform this presentation. If anyone has any comments, questions, or other feedback, please leave a comment in the blog posting. Thank you for taking the time to listen to my presentation, and I hope you have gained a better working knowledge of employer social media policies as they relate to the employee protection provisions of the National Labor Relations Act.